Good morning, Colorado. Welcome to the Bell and Pollock Legal Show. Gary Bell, Brad Pollock. We are injury attorneys. Our law firm is Bell and Pollock. Our website is championsofthepeople.com. That's championsofthepeople.com. And don't forget, it's an information-loaded website, all designed to give you information. There's some really cool features on that website. My favorite is the one called Meeting by Accident. You can click on Meeting by Accident. And when you do that, it gives you takes you to the answers to the most commonly asked questions people ask when they're involved in an accident. So it's pretty cool. There's a lot of other features that give you information there. And by the way, the podcasts of our shows, all our shows, including these shows, are on our website. They're at the bottom of the home page. So it's an information-loaded website. That's championsofthepeople.com. Okay, today is another sequel in our series on trucking liability, big rigs, big trucks, 18-wheelers. But before we get started on that, did you know that any truck weighing over 10,000 pounds is a commercial vehicle? And why does that matter? Why does that matter? Because if you're a commercial vehicle, you have to comply with the Federal Motor Carrier Safety Rules and Regulations. We'll just call them the Federal Safety Rules or the Safety Rules, but there are federal rules and regulations. And so if you've got a pickup truck hauling a trailer, and in combination, they weigh over 10,000 pounds, that's a commercial motor vehicle. So even though we're talking about big rigs, any other type of vehicle or combination of vehicles can qualify, and many times do qualify to be a commercial vehicle. How does that help you, the injured person? It helps you prove liability and responsibility once you've been injured. And let's face it, many of these injuries and these type crashes are horrific, terrible, devastating, catastrophic injuries, catastrophic events. Okay, just to bring you up to speed, we've been talking about in the past few weeks about fatigue. That's a big issue. Attorneys should look for fatigue. We always do when we have a trucking case. You also need to look for the logbooks. They're usually, not always, usually two sets of logbooks. One's falsified. And if you find the falsified logs, you can compare them against the GPS devices to see what the true location of the truck was and to prove the logs are false. How does that help you? It proves liability, and then you get into your damages and your injuries. So we're talking about big rigs today. We've also talked about texting and talking on telephones. That's illegal under the federal rules. Okay. Briefly, the state of Colorado has adopted by statute the Federal Motor Carrier Safety Rules, so they apply. You know, Brad, let's talk about disqualification of drivers first. There's a whole provision and provisions on disqualification of drivers, and what does it mean and who cares?
Well, it's very important. There is different standards that go with driving a big rig or a truck of this commercial vehicle. Some of the standards or some of the requirements that you must have or you become disqualified would not apply to driving a car. So, at times when you look and say, well, this person can drive a car, they're driving a pickup truck, they seem to get around fine, they're very capable. That's not going to necessarily apply to being able to drive a truck. For instance, in a truck, you're disqualified to driving a big rig, unless you have no impairment of a hand or finger, which interferes with power grasping. Well, a lot of people can drive a car with the one hand or with where the finger does interfere with power grasping, but in a truck you're not going to be able to do that. You can't be driving it with a CDL license and one of these big rigs with that situation.
And that's just one example. Let's face it. We say all the time at Bell and Pollock, our law firm is Bell and Pollock. We're injury attorneys. We've done this for years. We say all the time that a truck accident is not just another ordinary accident. If there is such a thing as an ordinary accident. It's certainly not like a car accident. And it's a completely different animal. And you better have attorneys who know what they're doing. You can call us anytime, 303-795-5900. In the mountains, you can call us at 970-870-8989 or our website, championsofthepeople.com. The point we're trying to make now are there are a variety of reasons, including medical conditions, including impairments, that can disqualify a driver from driving a big rig. And once they're disqualified, they're done. They're disqualified. They can't drive.
On some of these, it's a medical testing or a medical examination, and they're going to have to pass the medical examination to get back to being able to drive. Some of them is going to maybe or probably keep them and disqualify them for life. For instance, they have to have no established medical history or clinical diagnosis of diabetes currently requiring insulin for control. So, when you got a medical diagnosis of that, you're going to have to get rid of that medical diagnosis, but you still have the medical history. So you're probably going to have a problem ever driving if you got that kind of situation.
Right. And what you need to understand, and what your attorneys that do these cases need to understand, is you need to go after these medical records and medical conditions of the drivers. Normally, in a car accident case, that's why we said this is a different type animal. Normally, in a car accident case, you don't get the medical records. You can sometimes, of the driver of the at-fault driver, of the at-fault party. You can't. But under the federal rules, the driver cannot be driving that big rig or commercial vehicle as we've defined it if they're disqualified. And one of the ways they can be disqualified is a medical condition. And one of the ways is diabetes. And drivers are taken off the road all the time because they have diabetes. It's controlled by insulin. But if you have diabetes that is controlled by pills or other medical procedures or protocol, that doesn't mean you automatically qualify. You can just have diabetes. You can be a non-compliant diabetic and have a syncopal or a fainting episodes, and you can faint, lose control of the truck.
Well, and some of these are very hard to deal with. So, for instance, a clinical diagnosis of high blood pressure that's likely to interfere with the ability to operate a commercial motor vehicle, it disqualifies you from driving. If there's a certain medical histories of arthritic conditions or orthopedic conditions or muscular conditions, will disqualify you from driving. It means you're a disqualified driver, and that person is driving now, and it doesn't have the proper qualifications, should not be driving. It could hold both the entity that's hired him, the truck driving company, the commercial entity, the Target, Walmart, whoever he's driving for, and him responsible. But the problem, Gary, that you run into is, and it's really, I want to say it's a lack of education of the judges, because it's an attorney's job to make sure the judge knows. The judges who don't understand that and therefore, or don't know it, and therefore refuse to give you the medical records or refuse to give you access to medical records to the driver.
Exactly. And some of them are that way. They don't understand. They don't deal in the federal motor rules every day. And you have to have attorneys who understand it to try to put this matter before the court, try to get the discovery, try to understand and get the medical condition and the medical records of the driver. But why does it make a difference? I mean, so we keep saying, rhetorically, who cares? Well, we care a lot because you go after liability. You got to prove somebody did something wrong. And one of the ways you can do that is to prove they shouldn't even be driving. If you're a disqualified driver, you shouldn't even be behind the wheel. So, and they say, well, my medical condition didn't have anything to do with the accident or the way the accident occurred. Well, not so fast, because many times it does have something to do with the way the accident occurred.
It can be the small things that you're saying, hey, it shouldn't have anything to do with it. But the first thing you have to do before you as the attorney or you as the injured person, sometimes very significantly injured, before you as the person can determine whether it is you've got to know what the condition is, and then look at all the symptoms that could arise from that and determine whether or not the driver was having a temporary problem as a result of that condition. And you go back to the same thing. The driver shouldn't have even been behind the wheel.
Right. Shouldn't even be driving the truck to begin with. And so that's a way, not the only way, it's a way to prove liability, to prove responsibility. And we do it every day. You can call us anytime at 303-795-5900. That's 795-5900. In the mountains, you can call us at 970-870-8989. That's 870-8989. And an easy way to find us is just go to our website. It's easy, championsofthepeople.com. Championsofthepeople.com. It's an information-loaded website. You can email us. You can ask us questions. You can engage in live chat. And you can get answers to your questions without ever even talking to an attorney. Okay, so we're talking today about big rigs, commercial vehicles, usually devastating consequences. So you have to have attorneys to understand the rules and go after the federal rules and who violated what. So one of the ways we're concentrating on today is the condition or medical condition of the driver. But that also applies to the company, Brad, because once a driver is disqualified, he or she shouldn't be driving the 18-wheeler or the big rig, but also the company is prohibited, should not allow, I think the words are should not allow the driver to be driving.
No, they're not. They cannot allow it. They cannot permit it. A driver who's disqualified is disqualified for all purposes. And at that point, the carrier, the company that's hired or that's supplying the big rig, or sometimes, like we said, it could be the commercial company like a Walmart.
Right.
They're not permitted to allow the driver to drive, period. So now there's this extra duty. It's not just the driver himself. And you're going, okay, now that brings up a whole new array of questions, because now by implication, really by statute too, when we get deeper into the regs, we find out that there is a responsibility of the carrier to carry out certain medical examinations, to stay on top of the medical file of the driver, to know what's going on with the driver's medical history, and to get a full and complete disclosure and carry out medical examinations.
Right. So you need to look at the companies, the carrier. You also need to look at the driver. And why do we look at them? We look at them to see if they're responsible and liable. We look at them to see if they didn't follow the federal motor rules exactly. And all the police officers are well tuned into the federal motor rules. The state troopers are, police officers are, sheriffs are. When you investigate these accidents, that's one of the things they look for. And obviously one of the things they look for are the logs, and where are the real logs. And so, but we've covered that in previous shows. So we got a break coming up, but right after the break, we're going to talk about alcoholism. We're going to talk about some other medical conditions, and then we're going to move off into what does on duty, off duty mean, that sort of thing. You're listening to the Bell and Pollock Legal Show. This is the only show of its kind. Gary Bell, Brad Pollock. Our law firm is Bell and Pollock. We're conveniently located. We have an office in Steamboat Springs. We got an office in Denver at I-25 and Orchard, basically. Easy parking, easy access. You can call us anytime at 303-795-5900 or 970-870-8989. We are your champions of the people.
Ready for an extraordinary lunch? As fast or as slow as you want it, with all fresh ingredients? Caitlin's Restaurant has it all. Express lunches that won't keep you waiting. Or, if you prefer, lunch served in that old-fashioned homemade style. All made fresh, on the spot. Whether it's a fresh-made sandwich with homemade chips, quesadilla loaded with cheddar or jack cheeses, or scratch-made soups, you'll find everything you love at Caitlin's. Caitlin's is located on Mississippi just east of Colorado Boulevard next to Bookies. How about green chili chicken stew? Think about a variety of fresh-made sandwiches or 11 different kinds of burgers made to order with 1/2 pound of the finest USDA choice lean ground beef. You might favor a homemade New Mexican recipe with carne adobada burritos, chicken enchiladas, carnitas burritos, served with hash brown special recipe beans, cheeses with guacamole, and your choice of homemade red or green chili sauces. For those who prefer the lighter side, there are fresh made salads and lighter fares, sure to delight. Try Caitlin's for lunch or breakfast on Mississippi, just east of Colorado Boulevard next to Bookies. Call 303-798-6600. You'll love it every bite of the way.
Injured and confused? Confused about your injuries? Confused about the insurance company? Confused about which attorney to hire? So let's talk about attorneys. Let's get real clear on attorneys. I'm Gary Bell of the law firm of Bell and Pollock. You get to choose your attorney. So how do you choose? Experience? Yes. Handles only injury cases? Yes. Someone the insurance company knows? Yes. And respects? Of course. Attorneys who have been very successful representing their clients? Yes. Attorneys who don't deal in a hodgepodge of everything? Only injury cases? Mandatory. Attorneys who know all the tricks of the insurance company? Absolutely. Welcome to the law firm of Bell and Pollock. We do injury cases. We're known as the champions of the people. For a reason. We champion people's causes. And legal cases. Our website is championsofthepeople.com. For a reason. The reason is you. Come to championsofthepeople.com and see what that choice can do for you. Life has choices. Make your choice count. Championsofthepeople.com. There really isn't any other choice. Good morning. Welcome back to the Bell and Pollock Legal Show. Our law firm, we are injury attorneys. Our law firm is Bell and Pollock. Gary Bell, Brad Pollock. We're glad to bring this show to you each week to educate you, to train you, to give you knowledge and information. Knowledge and information is empowering. It empowers you to help yourself, protect your family, protect your loved ones. We cover a variety of different injury subjects on these shows if you've listened to our shows, and we're going to continue to do so. Today we're talking about big rigs, commercial vehicles, 18-wheelers. But remember, at the top of the show, I told you, any vehicle or combination of vehicles that exceed 10,000 pounds can be and usually are qualified as a commercial motor vehicle, and they have to comply with the federal rules. Sometimes they don't even know what the federal rules are. Okay, so now we're going to be talking about alcoholism, and that's one of the conditions. But you can have a mental condition that disqualifies you. You can have a physical condition, and alcoholism certainly is one of them, Brad. But generally, any condition that is likely to impede or impair the driver's ability to operate the big rig is disqualified.
That's really what they're looking for, generally speaking. Obviously, they get in more detail concerning certain things because they want to do away with The regulations want to do away with the argument. It's the old argument that we have in this state quite often now with marijuana is, okay, are 5 nanograms really enough to make you impaired? Well, they want to do away with that argument, and they're not saying we're going to do a presumption. They're saying, look, if you have certain of these conditions, if you've been diagnosed with these conditions, or if you have medical history, you're done. We're not going to have a hearing. We're not going to have an argument. We're not going to let you out there. And then if the accident happens or you get pulled over, we're going to determine whether or not, based on presumptions, we're just saying you're disqualified. And, that's a couple of the ones we're talking about. And a clinical diagnosis of alcoholism comes underneath those categories. It's not going to say, well, he's clinically diagnosed with alcoholism, but he's still, whether he's using or not, or when he uses or what. No, the bottom line is you're disqualified. Don't talk to him any further about the question.
Exactly, and there can be some discovery into this. But your driving record, if you have multiple DUIs, obviously you have an alcohol problem, and the driving record needs to be investigated by the company, and the driving history and the history of the driver has to be investigated by the company. Don't forget, listen, there's a position at these big trucking companies, and it's called the safety director. And the safety director is a very, very important position. The safety director is the person in charge of making sure all the drivers, all the rigs, and the company comply with the federal rules. So guess who you're going to want to depose if you're the attorneys. If your attorneys are not doing this and you're in a trucking accident, you're missing home base. You're missing first base. You're missing home plate because the safety director has to comply with the rules. What if you take the deposition of the safety director and they don't even know what the rules are? Or they only know what part of the rules are? Or they don't give an adequate enough training? And Brad, they've got to investigate the medical conditions. Every driver has to go through a physical, but the company shouldn't just stop there because the driver may have a condition that needs to be monitored, like hypertension, high blood pressure, or diabetes.
Right. And so the safety director, the first thing is the company has to have a safety director. If the carrier doesn't have a safety director, you better be really concerned because now there's real problems because that's kind of like there's nobody overseeing the classroom.
Right.
And you've just got people running wild.
That's a good example.
Right. So there has to be a safety director, period. Then the safety director has to be somebody who's on top of the medical conditions, on top of the physical conditions, on top of the social conditions. I know you say, what do you mean social? But social conditions, and in that I classify something like the fact that they have to be able to read and write the English language. A driver who cannot read and write the English language is disqualified from driving.
And disqualified, done, can't drive. As in can't drive. As in should not be behind the wheel. So if you can't read English or if you can't speak English or both, you have to do both, then you're disqualified. And the federal rules say when you're disqualified, you're disqualified. You shouldn't be and can't be driving.
Some other simple things, just very simple things. You're looking to say, well, you've got to have a safety director. You have to have somebody who's making sure the driver can see. The driver's not colorblind, can distinguish red, green, and yellow. Kind of important. But these are things that are spelled out. And the reason they're spelled out is because you've had people who sometimes ignore them and sometimes don't pay attention to them. And so you've got these things about here's the minimum required eyesight and hearing ability the driver must have and be tested for. These things have to be done or they're disqualified. It's not a question of saying, well, they're right in the edge, but it really doesn't adversely affect, and that's only presumption. No, it's called disqualification. And as the attorney, it's the job of the attorney when an accident has occurred to find out this information.
Right. You have to do it, and you can call us at any time at 303-795-5900, 795-5900, or in the mountains, 970-870-8989. That's 870-8989. We have an office in Steamboat Springs. We have an office in Denver. We do cases all over the state of Colorado. Our website, championsofthepeople.com. We even have a trucking video on our website. Why? Because trucking's accidents are completely different than a car crash. Car crashes are very important. People's lives can be drastically changed by car crashes. We're just trying to say that trucking crashes, big rig crashes, are a completely different animal. And you better have attorneys who understand the rules and go after this information. Okay, let's talk a little bit about when there's an accident. We were talking about alcoholism, alcohol, driving records, that sort of thing. When there's an accident, there has to be testing of the driver for alcohol. It has to be within 2 to 8 hours after the accident.
Alcohol and drugs. They're going to look at both.
That's right.
And when we're talking about it, normally that there's going to, if you can't get it done within the 2 to 8 hour time period, you better have a statement as to why it wasn't given. It better be a darn good statement. There better be an explanation, because the bottom line is that 2 hours is usually pretty easy to meet.
Right.
If you're given up to 8 hours and you haven't tested, then there's pretty much going to be a question mark next to that driver as to why that driver didn't go get tested within the 8 hour time period.
And the way this works in these big trucking companies, if you're a trucker, you're a driver there, you have an accident, you report the accident, somebody comes out to the scene, or they say you got to report to this clinic at this address right now to be drug tested and to be alcohol tested. That's the way it works. You go down to this clinic at this address and you are drug tested, and there's clinics that do just about that. That's about all they do is testing for trucking companies, testing for truckers and drivers. And so it's mandatory. But if you don't know these requirements, you don't know what to do, and you have to know these requirements.
And if the accident happens at 1 o'clock in the morning, you think that's going to leave them off the hook, or at midnight, and you say, well, it's off the hook because there's no clinic open till 8 o'clock in the morning. Don't be thinking that. There are clinics around just about anywhere you get in an accident. It's going to be very hard that there's not going to be a clinic or a hospital or someplace where the test can take place. And it's the job of the carrier to know where those places are. It's the job of the carrier to know where we can report. It's the job of the carrier to make sure that information is relayed to the truck driver. And it's the job of the truck driver to get there. So understand, when you're handling or when you've been hurt in such a situation, it's the job of the attorney to say right away, where's the test? And if there isn't a test, you say, well, show me where the information was given to the driver as far as where to report and why the driver didn't get there. And no, really, Gary, when we're working these cases, right, if we get a test that's 4 hours old, we want to know why it took 4 hours for the guy to get there.
Right, exactly.
You're at the scene, people attend to the scene, they take care of the accident, and you're usually released within an hour or two.
Right, and we're just touching the tip of the iceberg here. We're trying to educate you. We're trying to tell you you need attorneys to know this stuff. You can call us anytime at 303-795-5900. In the mountains, 970-870-8989. But let's say these trucks they don't have the record anymore. They say, oh, we gave a test, our driver went down for a test, but we don't have the record anymore. Well, then you can use that against them. That's not just the end of the story legally. They don't have the record. They should have the record. They should have done the test. Then you can use that again. Maybe they didn't like the results of the test. So you can use that. But you need to understand the rules. You need to know what you're doing. So Gary Bell, Brad Pollock, our law firm is Bell & Pollock. We are Colorado's premier injury law firm. Our website, championsofthepeople.com, and we are your champions of the people.
Ready for an extraordinary lunch? As fast or as slow as you want it? With all fresh ingredients? Caitlin's Restaurant has it all. Express lunches that won't keep you waiting. Or if you prefer, lunch served in that old-fashioned homemade style. All made fresh on the spot. Whether it's a fresh-made sandwich with homemade chips, quesadilla loaded with cheddar or jack cheeses, or scratch-made soups, you'll find everything you love at Caitlin's. Caitlin's is located on Mississippi just east of Colorado Boulevard next to Bookies. How about green chili chicken stew? Think about a variety of fresh-made sandwiches or 11 different kinds of burgers made to order with 1/2 pound of the finest USDA choice lean ground beef. You might favor a homemade New Mexican recipe with carne adobada burritos, chicken enchiladas, carnitas burritos, served with hash browns, special recipe beans, cheeses with guacamole, and your choice of homemade red or green chili sauces. For those who prefer the lighter side, there are fresh made salads and lighter fares, sure to delight. Try Caitlin's for lunch or breakfast on Mississippi just east of Colorado Boulevard next to Bookies. Call 303-798-6600. You'll love it every bite of the way.
Injured and confused? Confused about your injuries? Confused about the insurance company? Confused about which attorney to hire? So let's talk about attorneys. Let's get real clear on attorneys. I'm Gary Bell of the law firm of Bell & Pollock. You get to choose your attorney. So how do you choose? Experience? Yes. Handles only injury cases? Yes. Someone the insurance company knows? Yes. And respects? Of course. Attorneys who have been very successful representing their clients? Yes. Attorneys who don't deal in a hodgepodge of everything? Only injury cases? Mandatory. Attorneys who know all the tricks of the insurance company? Absolutely. Welcome to the law firm of Bell & Pollock. We do injury cases. We're known as the champions of the people. For a reason. We champion people's causes. And legal cases. Our website is championsofthepeople.com. for a reason. The reason is you. Come to championsofthepeople.com and see what that choice can do for you. Life has choices. Make your choice count. Championsofthepeople.com. There really isn't any other choice. Good morning. Welcome back to the Bell and Pollock Legal Show. We are injury attorneys. We're here to help you. We have an office in Steamboat Springs. We operate out of Denver. We do cases all over the state of Colorado. Our website, championsofthepeople.com. That's easy to remember, easy to go to, and easy to navigate. Okay, so we're talking about big rigs today. We've talked about fatigue, logbooks. Those are a whole subject. You could do a whole show just on logbooks, how you're off duty, on duty, not driving, etc. We've tried to cover that as much as we can. Let's talk about what if a driver, Brad, has a bad driving record, and how does that affect the company and the driver?
It could very well affect the driver, and obviously the company is affected when the driver is disqualified of just complete disqualification again. Now, it may not be lifetime. It may be lifetime. Lifetime is basically considered 10 years before you can once again seek qualification or seek to be able to get to be qualified again. But you're talking about disqualification that can last anywhere from 30 to 60 days to 90 days up to the lifetime disqualification. Very important that driving record be looked at and you determine whether or not the person should have been driving at all.
Right. And a bad driving record like multiple DUIs, multiple disregard for major traffic offenses can result in disqualification. That's 49 CFR 383.51. I just gave you a citation. We try to avoid citations, but there are so many of them. We know them at Bell and Pollock. You can give us a call, 303-795-5900. In the mountains, you can call us at 970-870-8989. We have offices in Denver and Steamboat Springs. We cover the entire state of Colorado. We are Colorado's premier injury law firm, and we are your champions of the people.